Hello, everyone, and welcome to this week's episode of our live webinar series, proudly brought to you by ImmigrationQuestion.com, your trusted source for up to date immigration news, expert legal insights, and live conversations with licensed immigration attorneys. My name is Anasia Mukherjee, and I'll be your host for today's important session, Mandamus. What is it? How can it help? And how should it be done for maximum effect? For many immigrants and their families, delays in immigration proceedings aren't just inconvenient, they're devastating. People wait months, sometimes years, for USCIS or a US consulate to act with little to no communication. But if you're stuck in this limbo, there's a powerful legal remedy and that may help, a right to Magnumus. In today's session, we're diving into what a Magnumus is, how it works in immigration cases, and what it takes to file one strategically to get results without putting your status at risk. We're honored to be joined today by Attorney Jonathan Wasden, a nationally recognized federal immigration litigation attorney with over 20 years of experience. Attorney Wasden is the managing attorney of Wasden Immigration Litigation and a former attorney with both the U.S. Department of Justice and the Department of Homeland Security. He's a top expert when it comes to high stakes federal court litigation, including Magnus lawsuits. You're welcome, Attorney Wasden. Thank you so much for being here today.
Thank you for having me.
Before we dive in, a quick and important reminder. ImmigrationQuestion.com is a two-in-one platform that connects users with licensed immigration attorneys. We are not a law firm and are not affiliated with AILA or USCIS. All legal services are provided independently by attorneys in our network. So let's dive into today's discussion. Attorney Wasden, let's start with the basics. For someone hearing this term for the first time, what is the writ of Magnumus and why is it used in immigration cases?
So the word mandamus is Latin, and it comes from a time when all legal proceedings were done in Latin. And what it means is we command. And it was a way of a court being able to order the government to take an action that it was required to take. And, so we have this from England. It kind of follows down to us. And then we've codified it in a couple of different ways in statute. We have a mandamus statute that is there, and we also have what's called the Administrative Procedure Act that allows you to sue and challenge the government if an agency action has been unreasonably delayed or unlawfully withheld. And there's a small nuance difference between those two things. But the APA standard is the one that I think is the best to go with, because we're really fighting about whether or not it was unreasonable or unlawful. And if either one of those things apply, then we can get a court to order the agency to take action.
Thank you. Now, immigration delays happen a lot, but not every delay qualifies for Magnumus. How does someone know if their delay has become unreasonable enough to justify legal action?
So there's a couple of different factors to look at. I mean, everybody who's ever dealt with any government, regardless of what country you're talking about, is familiar with the concept that government employees are slow, government is unresponsive, and takes a long time to do simple tasks. What we saw in the first Trump administration and what we're starting to see now is the agencies are altering their internal processes intentionally to slow down the processing of applications and benefits. So when the agency does something intentionally, then you have a much stronger case in court. So if we can gather information that they're doing this purposefully, it is what's called bad faith, and you prove bad faith, you win every time. The other thing is the agency is required to explain to the court that they have a rule of reason and that they're processing your case according with that rule of reason. If we have evidence, if we get their rule of reason of what the processing logic is, typically they claim it's first in, first out. If we get evidence that they are not processing your petition in a first in, first out manner, then that's again, almost a surefire winner, because we're able to show that the agency isn't complying with its own internal rules therefore it's unreasonable. So there's a lot of different ways to attack these issues. All of them require that you do some homework and you get some additional information before jumping off and before starting.
All right, thank you. Now, some people worry that suing the government might backfire. Can you explain how a Mandamus lawsuit affects your immigration case and whether it puts someone at risk of a retaliation or even denial?
So this is really a two-part answer. So
Mhm.
I'll answer the one issue about retaliation first. So having worked for the government, I can say, again, government employees are the same the world over. They don't get extra money for extra work that they perform. So if you show yourself to be somebody who's willing to make them do extra work, you tend to get actually treated better rather than worse. Because if you're a thorn in their side, you're going to keep going to court. You're going to keep making them do additional work. And litigation is a very labor intensive and time intensive endeavor for the government. So my experience was always that people who sued got treated better for that very, very simple reason. The other issue is once you're in court, the judge can come out with a ruling that actually has a great impact for you, the individual litigant, but also creates a rule that is going to have far-reaching effect far beyond that one case. And the government is very sensitive to that, and they can try and avoid bad outcomes in litigation by just giving in a lot of times. Now, in terms of Mandamus specifically, there was a time when I was at the Justice Department where you file a Mandamus case, and just to be done with it, they would reflexively go ahead and adjudicate the application or petition just to be done with it. For that very reason, because it takes a lot of work. And just as a reminder for folks, when we sue under Mandamus, we're not asking for a particular outcome. We're just asking for a decision. It could be yes, could be no. So when you would sue, you would typically get a response very quickly and be ready in court. You're already in court. If they deny that application, then you can pivot very quickly, amend your complaint, and challenge that denial. And the government's very aware of this. So historically, when you're in Mandamus and you get a decision, it's not going to be a denial. What we have seen change over time is that reflexive response from the government to just go ahead and approve once a Mandamus case is filed has changed. It really did change starting in the tail end of the Biden administration, where they just decided they were going to defend everything. And you see a lot of people who have done template litigation. They get a copy of a complaint from somebody, fill in some blanks or change some letters. And all of a sudden they're caught in this new milieu where the government is challenging that. They're filing a motion to dismiss. And these individual pro se litigants really are ill-equipped to respond to a motion to dismiss. And that does a couple of things that are bad. It's going to cause you to lose your case because you just don't know how to argue that motion. The other is it's going to lead to judges making decisions that are going to be bad for everybody else in the future. So right now is definitely a tricky time to go it your own, but just that's a word of caution and a word of warning I'd throw out there for people.
Definitely. Thank you. So, timing seems crucial here. In your experience, what is the ideal moment to file for mandamus? And are there cases where it actually is better to wait or use another remedy first?
So, as a general rule in the U.S. Code governing immigration applications, there's a presumption that when you're dealing with an immigrant visa application, that the government should wrap everything up within 6 months. The non-immigrant, it says 30 days. I would say if you go into court challenging a delay of 30 days, you're going to lose 100% of the time. So kind of the rule of thumb that I'm looking at when I'm looking at a mandamus case is, are we beyond the 6 month mark? Because 6 months is a long time especially if we're dealing with an non-immigrant application where you have a very limited duration that you're eligible for. So I would say that's the criteria. Now, that's different than when you should start preparing for the mandamus case, because you can't just go into court and say, hey, it's been 6 months, we need a decision. Or you can't go into court and say, your online case processing times for this particular visa category are X, we're at X plus one. Therefore, I need an order to make them adjudicate my case. That's not going to cut it. So you need to start doing some additional work earlier on and filing Freedom of Information Act requests about the agency's processing metrics and their processing rules, and also data showing whether or not they're complying with those rules. You do that FOIA litigation early, or not litigation, but you do that FOIA request early on. And then when you're ready to sue, if the government hasn't given you that data, then you can include that in your lawsuit. You can do a side-by-side FOIA claim with your mandamus claim. That's an incredibly powerful tool, because if the government loses the FOIA lawsuit, they're statutorily obligated to pay your attorney fees. So that is a huge incentive for the government to settle those cases. Not only that, they don't want to give you that information that you've requested in FOIA, because it's going to be damaging to their case, their defense. And once it's out there, they can't control who has it, and they can't control who's using it in future cases. So by coupling the FOIA with a mandamus case, you create a lot of different leverage points that help you, get the government to come to the table and settle the case and give you the decision you're looking for.
All right, thank you. So my next question would be, for those who want to go ahead with mandamus, what makes a strong filing, and what kind of evidence or preparation is needed to increase the odds of success?
So let's just talk about what a typical government defense in mandamus looks like.
Mhm.
You file your case alleging unreasonable delay. The government's going to come back 100 times out of 100 with a motion to dismiss, asking the court to get rid of the case because the plaintiff hasn't established their case. With that motion to dismiss is going to be a very generic declaration from some government official within USCIS, probably at the office or service center that's responsible for adjudicating the case. That declaration is just going to say, we are processing this application in the ordinary course. We're following our internal rules. The petitioner, the plaintiff in this case, is just seeking to jump ahead of other deserving applicants in line, and they're trying to disadvantage other people to their benefit. That's the whole point of that declaration. If you don't have evidence to rebut that, you lose. And so that's why that Freedom of Information Act process is so important, because that's the only way you're going to get evidence in these cases. In a mandamus case, an APA case in general, there is no discovery. There are no depositions that are allowed. But when you couple it with a FOIA case, you do get that evidence, and you do get the leverage to get the information you need to prove your case. But you've got to think about it well in advance, and you've got to make the right requests so that the judge can order them to produce the right evidence you're going to need to fight the case.
Definitely. Thank you very much, Attorney Wasden. This session so far has been educational, and I know our audience agrees. To everyone joining us from Facebook, YouTube, and LinkedIn, thank you for being here. Whether you're a legal professional, community advocate, or someone just looking to understand this better, we're grateful to have you here. And if this is your first time with us, welcome. We are immigrationquestion.com, a two-in-one platform built with lead and case management features to help simplify the immigration process. Though we are not affiliated with AILA, we are trusted by a lot of AILA attorneys who use our platform. Also, with immigrationquestion.com, you can ask your immigration questions in any language and get connected to a licensed attorney for free legal guidance. And yes, just like many of our users, you can also receive a free confidential initial consultation. Just visit www.immigrationquestion.com to learn more. And it gets better. We just launched our new mobile app designed to make access even easier whether you're a user or an attorney. Attorney Wasden, as an immigration litigation attorney with over 20 years of experience, what would you say about what immigrationquestion.com is doing for the immigrant community and immigration attorneys like yourself?
It's a valuable resource. It helps us, reach the clients, helps us do our jobs. So it's great to have you out there.
Thank you for that. It makes us glad to know this. Before we dive into our live Q&A session, let's talk about practical strategies. So, can you walk us through the actual steps of filing a mandamus lawsuit from deciding to sue to getting a response from USCIS or the court?
Yeah. So right now, you can look and see what the processing times are, and you can compare that to historical processing times. And you see that they're starting to balloon, that they're getting much larger. So you file your application, and at the time you file your application, you're out very little to file that Freedom of Information Act at the same time or shortly after. What the FOIA claim request does is it starts a process. The government has 20 business days to respond. So regardless of when you file that FOIA, you want to do it at least 20 business days prior to your lawsuit. If the government doesn't respond within those 20 days, theoretically you could go to court immediately. If they do respond and then you don't like their response, most of the time those FOIA responses are meaningless and worthless, and they play dumb and say they don't have any responsive evidence when you know they do. So if that's the case, then you have to do an appeal. And then after the appeal, you get your ability to go to court, or you get the evidence that you were seeking through FOIA. When you go couple these things together, when you go to court with a FOIA with the Mandamus case, then you have direct access to the U.S. Attorney's Office, and you start negotiating what evidence you're going to get and when they're going to give it. I will say that when we couple these things together with a very thorough, well, strategically planned FOIA, we haven't really seen a whole lot of pushback from the government on your Mandamus case. And the terms of settlement in these cases have been drop your FOIA, which, for the individual client, that's an easy decision. We'll gladly get rid of the FOIA. We get the decision, and we're happy, and we go with that. So, I keep talking about the importance of FOIA, but it is the biggest single piece of leverage that you're going to have in this process if you do it right. If you do it right, that is going to cause more concern for the government than just about anything.
Definitely. Thank you for that. We're now moving into our live Q&A session. So if you've got a question for Attorney Wasden, now is your moment. Drop your questions in the chat or call us live at 516-703-3483. All right, so our first question is, I'm scared that if I file a lawsuit against immigration, they'll retaliate or deny my visa. Has this happened to anyone?
So retaliation, it's illegal. Now, the caveat being in the Trump administration, them doing illegal things is not necessarily unheard of. However, when they deny your visa, they have to explain the legal basis and the factual basis for the denial. If they don't do that, a court will overturn their denial. If you're already in court, you have access to the court. The timelines are going to be very quick. You could pivot very quickly and change your mandamus case to a challenge of that denial very easily. And the government is aware of this. So we don't see reflexive retaliation and denials of visa application or petitions and stemming from mandamus. You just don't. The only denials you're going to see are ones that they would legitimately deny anyway. So if you have an approvable case and it's a meritorious filing, Mandamus has nearly zero chance of having a negative impact on you.
All right. Thank you. Next question is, what if I get approved after filing my mandamus? Should I withdraw the case or keep it open just in case there's an error?
So when you're filing mandamus, you're asking the court to make a decision on the delay. Once the decision has been made, the delay is gone, and your case is what's called moot. There's nothing there. And so if you keep pressing forward, the court will dismiss your case because you have received the remedy you went into court asking for. The only way you really keep a case alive is if you have a FOIA claim that is still live and you want to litigate. However, if the government's saying to you, we will adjudicate your case if you dismiss your FOIA claim, you really got to think hard about taking that, because what you want and what's useful to you is a decision on that application more so than the data that you're requesting in FOIA. So I would say in almost every circumstance that I can think of, once you get your decision, you dismiss the case.
All right. Thank you. Next question is, can I file a writ of mandamus myself, or do I really need a lawyer? I can't afford one right now.
I mean, you can always go pro se, which means doing it yourself. However, when the government files their motion to dismiss, you got to ask yourself, how are you going to respond to that? They're going to come in, they're going to have a whole bunch of legal authorities, legal cases that are going to be citing. I mean, are you really equipped to read and understand those cases and point out the legal flaw with the government's argument? And are you equipped with the evidence that you need to rebut the declaration that the government's going to put in your case? If you're not only will you most likely have a bad outcome for yourself, but you could create a situation where a judge rules on your case in a way that has a bad impact on many people in the future.
Okay, thank you. Next question is, my asylum case has been pending for 4 years and I haven't gotten an interview date. Will a writ of mandamus help move it forward?
Potentially, yeah. So again, what you would want to be doing is start looking at your very narrow circumstances. Which office has your case? What are the requirements for your particular asylum case? And start doing FOIA claims to see how they're treating people similar to you. So you're comparing apples to apples. And if it most likely there really is no justification for this delay, especially in this current environment where they have raised fees for the last few years to cover and increase the efficiency of asylum adjudication, I think there is definitely some arguments to make for long delayed asylum claims. There really just doesn't seem to be a legitimate reason for how long these things are taking.
Makes sense. Next question is, what are the chances of winning a mandamus case for a stuck fiance visa? My embassy hasn't replied in over 18 months.
So I guess we should have earlier on to separate it out. We've got USCIS cases and we've got the State Department cases. And this is a State Department case. My guess is they are in administrative processing, or 221G.
Mm-hmm.
When they put you in 221G, legally what they're required to do is let you know the basis, why, and also provide you with information that would allow you to provide evidence in response to overcome the 221G. They never do. They never comply with that rule. So if you're in that situation, you have one of two options. One, you contact what's called LegalNet. And LegalNet is an office, State Department office, run by lawyers. You vet legal problems through them, and if they agree with you, reach out to the consulate and tell the consulate to come correct and fix what they're doing wrong. You may want to work through LegalNet, But if you don't, again, FOIA and then go to court. When you're in court on a 221G, one of the key pieces you're looking at is in an unreasonable delay case is, did they comply with the law? Did they give you an explanation of what the problem was and how you could overcome it? Because if they didn't, you're really close to just having a per se unreasonable action by the government. They're putting you in limbo with no explanation of how you can get out of it. And that is something that I think is a strong case, especially for a fiance visa that's been going on a year and a half and delay it like that. So I tend to think those cases are good where the government hasn't complied with their own rules.
All right, thank you. Next question is from the audience is, can I still file a mandamus if USCIS says my case is still quote unquote within normal processing time? It's been almost 2 years.
Yeah, so them saying it's within normal processing time is questionable. Do we trust what they're saying? In dealing with USCIS and their numbers, I have to say I don't really trust what they're saying. The other thing is, what's their evidence that this is within normal processing time? They just push that out there, and what does that even mean? Nobody really knows what that means. So you push, you make some waves, you do your FOIA, you make them prove that it's within normal processing times through the FOIA process. More times than not, they can't do it, and if they actually turn that evidence over to you, they're going to be showing a flaw in their system and the flaw in their analysis that can be used in future cases. So that's a huge incentive for them to get rid of your case just by giving you a decision.
Okay, thank you. Next question is, my FOIA request for my immigration file is being ignored, sorry, and I need it for my deportation defense. Can Mandamus force them to release it?
So in this situation, you wouldn't actually file a mandamus case because the Freedom of Information Act itself creates a cause of action. So you'd be filing your case under FOIA, and you would say that the government has not responded in the required amount of time, and they're required to do so. If you're successful, the upside to this, if you're successful and the court agrees with you, the government has to pay your attorney fees. One of the strangest and oddest things in the world to me is how the lengths to which USCIS will go to avoid paying attorney fees to an attorney. They hate that more than they hate giving in and giving you the benefit that you're requesting. So if it looks like they're going to have to pay attorney fees, they are really going to work hard to settle that case.
All right, thank you. And our last question is, what kind of proof do I need to show that USCIS is quote unquote unreasonably delaying my case before filing mandamus?
So when you're suing under mandamus, the court looks at 6 different factors. One of those factors is, are they processing applications according to a rule of reason? That rule of reason in most times is going to be described by USCIS as a first in, first out. So when you're doing your FOIA requests, you're looking for data that's going to show whether or not over a period of time they're actually doing this first in, first out. And if you can show through the FOIA that they're not complying with their rule, then you've got them cold. They're not following a rule of reason, and it's just random or willy-nilly. So that's the kind of thing you're looking for.
All right, thank you. That was the last of our questions from the audience. So this has been a very insightful session. Thank you again for joining us, and a huge thank you to Attorney Wasden for the practical strategies and insights you brought for today's session. I hope this discussion gave the audience clarity on mandamus writs. Don't forget, at immigrationquestion.com, you can ask your immigration questions for free and get in touch with a licensed immigration attorney who understands your case. You may also be eligible for a free confidential initial consultation. So head over to our website, www.immigrationquestion.com, and sign up today. And if you want to revisit this session or share it with a colleague, you can catch this replay on Spotify. Just search Borderless Talk by immigrationquestion.com. Also, for all immigration attorneys in the New York City area and surrounding areas, you are invited to join our in person event in Long Island City on July 24th. Enjoy the company of like minded professionals over food and drinks while learning how to scale your practice. Head over to our website to RSVP. Join us again on Friday for another enlightening conversation on a major immigration issue. Trust me, you don't want to miss it. Once again, thank you so much, Attorney Wasden. We can't wait to have you back again.